Bună ziua! Bine ați venit la conferința organizată de Asociația Specialiștilor în Confidențialitatea și Protecția Datelor, sub titlul Biography of the Last 6 Years of GDPR in the European Union Member States. Agenda conferinței acoperă teme interesante pe care le vom discuta cu onorații noștri invitați, pe care îi voi prezenta imediat. Pentru că este de data aceasta o conferință cu prezență internațională, voi continua în limba engleză, astfel încât să-i ajutăm și pe invitații din panel să înțeleagă ce vorbim. So, welcome everybody to the conference. I will present our guest that will provide us an overview on the GDPR implementation in the last 5 years. So, we have the following experts in the field of data protection with us. We have Maria Moloney from Ireland. She's a senior data protection and security and artificial intelligence specialist in Privacy Engine, an Irish technology company. Maria holds a PhD degree in design research for privacy, risk management, engineering, so in data privacy field, so very, very interesting. She has an experience of 20 years in international privacy, security, and currently also in artificial intelligence. She is also Data Protection Officer for European Cost Action, entitled FinTech and Artificial Intelligence in Finance. She will introduce us in the artificial intelligence governance and its related challenges. So welcome, Maria. Maximiliano Papalardo from Italy. He is a lawyer specialized in data protection, law of new technologies, and intellectual property. He is a partner in Ughi Annunziante law firm. Also, Maximiliano works as a data protection officer for an Italian multinational company in fashion sector. So very interesting for us, ladies. He holds CIPP certification from 2014, and for 2 years, 2020 and 2021, activated as a member of the European Advisory Board of IEPP, International Association of Privacy Professionals. So welcome, Maximiliano.
Good afternoon, everybody. Thank you, Maria.
Thank you. Paul Olivier, France, so he's the president of French Association of Data Protection Professionals. He also founded Digital and Ethics in 2012, so long ago, with the aim to develop new tools to ensure ethical use of data. So we hope to learn more about it during the conference. So welcome, Paul Olivier.
Thank you very much.
And Daniela Cireașă, who most of you know, she's the president of the Association of Privacy and Data Protection Professional, so here in Romania. She's also certified data protection officer. She has many certifications, so I will just remind the PCB certified data protection officer and trainer, both certification being internationally recognized. Daniela is also NetSpace founder and also branch president of CONAF Brăila. This is the National Confederation for Female Entrepreneurship. So welcome, Daniela, and also congratulations for your support in organizing this event.
Thank you, Maria, and welcome to all the speakers, and thank you all for accepting the invitation to debate together such a challenging topic as the status of GDPR implementation in the member states.
Yeah, very honored. So before I invite our guests to speak on the topics they prepared for us, we will spend the following 50 minutes in looking to a helicopter view on what happened in Romania from 2018 onwards, for some statistics even before, supported by the official figures published by the Romanian DPA, ANSPDCP. I hope that I calculated them right. Of course, I'll provide also my opinion briefly in retrospect on the implementation of GDPR in Romania, having prepared a few slides as a support. Here I will ask the technical colleagues. Okay, so we have it. Yeah, so how GDPR started to be implemented in Romania? If you all remember, in 2016, so we had the GDPR adopted, and we had a lot of consultants starting to talk about GDPR and about these 2 years of transition, and of course about the fact that this GDPR comes into effect in 2018, and with a large with different kind of sanctions, especially the 4% of the turnover or the 20 million euro from the turnover of the company. So in 2016, 2017, the large companies started to pay attention to this, and 2017, 2018, it was here, I don't know, hundreds, thousands of projects of gap assessment, mostly of them, of course, by the large companies implemented with the support of the external consultants, but not only. So there are also medium enterprises that started to be careful with the GDPR and how the new rules are implemented, especially that based on a gap assessment. Of course, we should have kind of a lot of measures implemented, but not all of them were there in practice. Clear, we had a lot of problems with this. We saw as well that in 2018, a lot of small and medium enterprises started to implement various templates that were available on the market. Some of them did not, let's say, update it to the data processings that the organization was performing. 2018 was a year of conferences. I remember multiple conferences that have been organized in Romania, most of them with the participation of our DPA, so the representatives from Ascpd. Also, in 2018, we could have seen a lot of requests for consultation addressed to the National Data Protection Authority. So it was a great interesting GDPR implementation, and also in learning how some of the problems identified would be or should be addressed. In the area of public sector, we still have a lot of things to do, also in sector private, but especially I'm talking about state institutions, because I think there we really need to have DPO appointed. We know that it's a big and large room to be improved in all the sectors, but especially also in the sectors, schools, or I don't know, medical units and so on. If we look briefly on the statistics, so that I collected from the reports of our authority, I also added 2016 and 2017 to see as a comparison how much the things have been changed or not. For instance, what we can see, and this is a benefit, I would say, for the business, in the terms of international transfers for the experts that were doing data protection also before 2018. You remember that every transfer should have been notified to the authority, and wherever there was not an adequate decision from the European Commission, or there were not binding corporate rules. So we needed also an authorization from the authority, and you can see the figures there. Of course, from 2019, we didn't have any more this activity in the role of, let's say, data protection departments within the organizations. Also, in Romania, there was this obligation to notify the data processing that implied a high risk to the authority. And here in the first years, you can that I addressed here, you can see that there were thousands of notifications. Mostly, if we look into this data processing are similar with the ones that are embedded in Article 35 from GDPR, when we need to run a data protection impact assessment. which means actually that at least the companies that previously notified those data processing activities should have prepared by now a data protection impact assessment, especially that after 3 years of GDPR, we have this obligation, including for the former activities already notified to the authority. You remember that a review of the data protection impact assessment, it was mentioned that should be done at least after 3 years, if not ad hoc, if changes appear. In terms of opinions, you can see that in 2018, they almost doubled. 2019, okay, the trend was increasing, but then 2021, 2022 started to decrease. Or in terms of legislative processes, when our authority is involved, is asked to offer its opinion in 2022, they had to deal with, let's say, the highest number of the bills, 107, which means that actually the initiators of the bills started to be aware of the fact that they need to take into consideration also the data protection impact on whatever they legislate. If we go forward and look into the complaints, we'll see that in terms of complaints received by the authority in 2018, large number of complaints compared with the period before the GDPR. In 2022, started to decrease. However, out of this, you can see the number of the investigations that have been initiated by the authority following these complaints received and registered by the DPA. Sanctions were also before the GDPR. If you look, they were the number was larger, even if Romania, for the number of the sanctions positions itself on third place after Spain and Italy for the assessment done for 2018-2021. Fines, they are total fines. The numbers are not high because before the GDPR we had fines of 1,000 lei. This was kind of 200 euro. But in 2018, we know that our authority was very much focused on prevention and of making a lot of activities in the awareness field. So there were warnings or not even, but there were a lot of discussions. And then from 2019, the sanctions started on GDPR as well. In terms of investigations, there are caused by the data breaches notified or complaints related to data breaches. What we can see from 2019 is the following trend, that the authority investigate every data breach notification that it receives, which means that everything is investigated, mostly in writing, as far as I know. But still, this is a taken point from here. Sanctions, of course, they started to increase. If you look in 2022, we have fines doubled compared with 2021. And also in the terms of warnings, we have again doubled, measures doubled, so everything is doubled. This brings me to the overall of the sanctioning enforcement area, including at the level of the European Union, when we can see in the right corner, in 2018, we started with €500,000. 2019, we talk about millions, 72. 2020, doubled almost, even more. 2021, 1 billion. 2022, 1.64 billion, and 2023 only Meta took 1.2. If you remember TikTok, if I remember well, 345,000 K. So a lot of sanctions here. In Romania, as a summary, as I told you, every data breach notification is investigated by the authority. our authority started also to impose some fines to a level that was not known for us until GDPR. Still, comparing with the other countries, Irish, not to say, yeah, they are, let's say, reasonable. And I would say that usually the authority was reasonable. And I will want to point that they also concentrated on prevention, awareness, education mostly. But still, we cannot ignore the fact that also the individuals that are processing data, that are processing personal data without a legal ground, for instance, or without information, but mostly without legal ground, they started to be fined from 100 euro to 2000 euro. So these are the, let's say, the amounts that our authority went for. I wouldn't want to spend a lot on this case, but for me it was very interesting, this case, Clearview, that is based on the artificial intelligence, but I would leave our colleagues to discuss about it. What I would like to underline is the fact that the same company took 20 million euro fine from 3 different authorities for actually processing by biometric technologies of face recognition, millions of personal data from millions of data subjects without having a legal ground, so by violating all the transparency or the legitimacy principles. So coming back to our guests today, I'm sure that they will explain us interesting things, and we shall pay attention to see how and how it is the trend actually in other countries, what we can do as a data privacy experts, as a DPO, for instance, be employed in-house in an organization, so that to avoid sanctions, to avoid breaching the data subject rights, and be as much as possible on the line of GDPR and Europe and the national legislation. So thank you for your attention. Now I will not spend more time, because I know that we have a limited time. And I will invite Maria Moloni to speak about future challenges in responsible artificial intelligence governance. So Maria, the floor is yours. Thank you very much.
Thank you, Maria. I'm just going to bring up my slides now. Oh yeah, there they are. Thank you, and I'd like to say thank you to everybody for inviting me here today. I'm very excited about talking to you about the AI Act and data protection. I was in your lovely country in October. I was in Cluj-Napoca because I do some research collaboration there in the University of Babeș-Bolyai. I hope I got that right. So they have a platform called Tech Economics, and there was a conference there in October, and I have collaborated for many years with that university through the cost network that I'm involved in. So, and I'm excited because hopefully I'll be visiting again in April this year. So let me get started. Today I'm going to talk to you about the EU AI Act and what that means for data protection officers. So I'll give you an overview of what I want to talk about. I think I have 20 minutes, so I want to just give you kind of a background of my understanding of why the AI Act was so important to Europe and why they've spent the last 2.5 years working really hard to kind of get this up and running and get it to be the first regulation globally. Then I'll talk to you about the key takeaways that I think the AI Act will be important for data protection officers. I'll go through the 4 categories of risk that are within the AI Act. And then I'll talk about the general principles as well. So there's 6 of them there, and they're very similar to the principles of the GDPR. And then if I have time, I'd like to talk to you a little bit about how to prepare for the AI Act, because it's coming quite shortly. It's coming in the summer. Us as DPOs or privacy professionals, how do we prepare for AI compliance given the AI Act? So, oh, that's quite small actually. So I just want to give you a background of my understanding of why Europe saw this as being kind of important to get right. So Europe has kind of a history of ensuring fundamental rights for their citizens, and they take it quite seriously. As you can see from the GDPR, you know, we're kind of the gold standard now across the globe for GDPR, for data protection. And I think they wanted to keep that kind of momentum going with the AI Act. So we've all seen the kind of the damages that the AI systems can do. We've all had experiences, we've all read in the news, certain biases and errors that can come into the algorithms of the AI system. So Europe wanted to ensure that in terms of like fundamental rights like healthcare, education, border surveillance, and public services, that these systems do not cause harm to the European citizens. So it's the first of its kind, and Europe was very quick off the ball in terms of regulation. They came to an agreement in December 2023, and I think it's a kind of a historical achievement for Europe to get this, you know, up and running. So they're working on it now, and hopefully it will be applicable by this summer. And then we have like we have various different kind of goals to meet. So like 6 months time, we'll have the banned applications being taken off the market and so on, up until 36 months when the entire act will be fully applicable across Europe. So what are the key takeaways then for DPOs? So who does the AI Act apply to? So it applies to the developers of AI systems and deployers, and as well a lot of other entities across the value chains like importers, distributors, and authorized representatives of AI systems. But I'd like to talk a little bit about developers and deployers and why they have distinguished these two entities. So developers of AI systems are people like, you know, OpenAI, where they have large language models, and then further on down the value chain, these large language models get deployed by various different industries, and they get used in various different ways. And it's very hard for the developer to actually foresee how these large language models or these general use AI systems will get used along the value chain. So that's why they've included deployers, because I think deployers are they're best placed to kind of carry out impact assessments and so on, because they are the ones that will understand how the AI system will be specifically used in their deployment. So that's why they've included both developers and deployers of AI systems in this act. So what is kind of regulated in the act? So we have a definition of AI systems, and the powers that be in Europe have decided that they would go with the OECD definition. And I think they did this because they want to future-proof the AI Act, but they also want to reduce the complexity of understanding what's in scope within the Act and what's out of scope of the Act. So by adopting the OECD definition, they're kind of adopting a kind of a global definition of AI, and they're kind of setting the bar for other legislation that will be coming down the line. Which industries are affected by the AI Act? Well, that's all industries, and it's very similar to the GDPR in this respect, that it's what we call a horizontal regulation. So it cuts across all sectors and all industries. And then what are the requirements? And again, the AI Act is similar to the GDPR here in that it's a risk-based approach to regulating these technologies. So depending on the risk assessment of your system, you have different levels of obligations under the Act. Okay, so moving forward. So, like I said, I'll talk about the 4 categories of risk, and the AI Act kind of focuses on the top 2, which is unacceptable risk and high risk. Because limited risk and minimal risk, they really only have kind of transparency obligations under the AI Act. So the focus has been on unacceptable risk or like AI systems that will be within 6 months, they will be banned within the EU. Once the AI Act becomes applicable, organizations have 6 months to take these unacceptable risk AI systems off the market. And then there's another category called high risk that I'll get into in more detail as we go along. So what are the banned AI systems? So we have things like real-time biometric facial recognition by law enforcement. That would be classed as banned. The only time law enforcement can actually use this real-time facial recognition is in 3 instances. So the first instance is if they're looking into a serious crime, and the AI Act lists out what it understands to be serious crime, like murder and rape and so on. The second time they can use it is for terrorist attacks. And then the third time is, what I can't know, what is the third time? Yeah, so say a missing persons, that's the third time. So any other time, these facial recognition systems cannot be used by law enforcement. So untargeted scraping of facial images from the internet or from CCTV footage will also be banned. And I know that you were talking earlier on, Maria, about Clearview. So they got a lot of fines, and I think, and I'm not 100% sure here, but their AI systems would have to really look and see if they can actually be used in Europe, because they look at facial recognition and they create databases of facial recognition. So that's kind of a question mark there for them. Emotion recognition, so any kind of AI system that looks at or looks to record emotion in the workplace or in educational institutions will also be banned. Social scoring, so AI systems that kind of calculate social behavior, they score people based on individuals' personal characteristics or their social behavior, from their social media accounts and so on, will also be banned. Any systems that try to manipulate human behavior to circumvent their free will, and I think we had cases in 2016 of Cambridge Analytica trying to manipulate people into voting for various different parties in the US. That kind of AI system will definitely be banned now in Europe. And any kind of AI system that will exploit the vulnerabilities of people as well, due to their age or if they have a disability or because of their social economic situation. So that's the list of banned systems. Now moving on to high risk systems. So these will be on the market, these will be allowed to be within Europe, but there's a lot of obligations that they will have to meet before they can actually, access the European market. So any kind of AI system that has to do with critical infrastructure like road traffic or the supply of water, gas, heating, electricity will be deemed as high risk. Again, in the education sector, when we talk about, learning outcomes or kind of trying to steer the learning process or monitoring cheating, this will all be considered high risk as well. In the employment sector, you have like AI systems that process large amounts of CVs, and they filter through people's applications to decide on the best type of individual for the job. These will all be considered high risk. And any kind of AI system that provides access to essential private and public services or benefits like healthcare or creditworthiness, or whether you're entitled to a loan or not, will also be seen as high risk. So moving on. So that's kind of the 4 different categories that we have within the AI Act based on risk. And then between the European Commission's draft of the AI Act and the European Parliament's draft of the AI Act, they introduced 6 general principles. And again, this is similar to the GDPR in terms of having general principles. And I think they introduced these 6 principles because, again, they were trying to future-proof the AI Act. So in the annexes, they have a lot of use cases that they provide to organizations so that the organizations can understand whether the AI system is within the category of high risk or not. But it's very hard, like I said before, it's very hard to predict how these AI systems will be used in the future. So again, it's very hard to provide use cases because we don't know how they're going to be used. So they've provided these 6 general principles as kind of a catch-all. So if the case studies do not provide for like future scenarios, then you can always fall back on these general principles to kind of understand what your obligations are. So again, so they've made the first principle human agency and oversight, and I think this is going to be a big challenge for, especially for like the financial. A lot of fintech companies now have AI first business models, and they're trying to eliminate the human oversight within those business models. So again, they're going to have to try and, they're going to have to grapple with how to move forward once the AI Act comes into place. Technical robustness and safety, of course, you have robotics and so on. So it's paramount that these kind of AI systems are fully tested technically, not to cause harm. And then privacy and data governance. And, so this has been my interest in AI was driven by the fact that my background is in privacy. And I could see the challenges of AI systems when it comes to data protection and privacy and so on. So it's great to see that the third principle is fully, data protection and that's being considered. Again, another important principle of the GDPR was transparency, and you see it here again in the AI Act. It has its own principle, like the fourth principle is transparency, which again is quite challenging with AI systems. Diversity and non-discrimination and fairness, and I think we've all seen in the papers, or we've all read these situations where AI systems have kind of built-in biases or built-in errors, because again, these AI systems were created by humans. Humans have biases, and they're prone to error, and so they get built into the AI system. So it's important that that we, as much as we possibly can, ensure that before these AI systems are put on the European market, that they're as fair and they're as non-discriminatory as possible. And then social and environmental well-being. So again, you have the challenge with AI systems where they process huge amounts of data, and so a lot of them could be quite environmentally challenging. So again, you have to, there's the consideration there of the long-term use of AI systems and how to reduce the amount of energy that these systems will use for the environment. So I think, these 6 principles are quite comprehensive. So what are the challenges then? So again, so we're privacy specialists, we're DPOs. So what has AI got to do with us? And again, we've seen like the third principle is data protection and privacy. And I think that DPOs, regardless of whether we will take on the governance of AI, we have to be at the table, because when you look at these challenges, there has to be some sort of input from data protection specialists when considering the following challenges, like training the algorithm with high quality data to avoid biases. So the more data that you put into an algorithm, the more refined the algorithm, depending on the quality of the data, of course, but the more refined the algorithm will become, and the less likelihood it is to be biased. But when you think about personal data, and the GDPR talks about data minimization, then the challenge here is that by putting huge amounts of personal data into an algorithm in order to train it, it kind of almost goes against data minimization. But it's needed, you need to put in that level of data in order to make sure that the algorithm avoids biases. So there's that conflict again. And it's important to have a privacy expert at the table when this is going on, because we need to understand, and we need to make sure that there's organizational protection and there's IT protections in place when this personal data is being used for training the algorithms. Now, I'll talk a little bit later. I have a slide on human oversight when using AI systems, but again, we've seen a lot of AI systems are being used to reduce the cost of labor and to eliminate the human being from the equation. And that can cause problems for humans because, you know, AI systems don't have that kind of, they don't understand the context, or they don't have the understanding of nuance like a human would. Then moving on to unforeseen uses and implications of AI. And again, like we said, the developers of AI systems often can't foresee how these AI systems are going to get used. And that's why we've seen like obligations put on deployers of AI systems, because it's the deployers that will understand how they plan to use the, you know, the AI system. And again, that creates challenges because when you're developing an AI system and you don't know how it's going to be used, how can you do an impact assessment on those systems? So again, the right to an explanation and transparency of processing, which we've seen in the GDPR for the last 6 years. How can we ensure that every individual is entitled to an explanation from a decision that's been made from an AI system, and nobody really understands how the AI system got to the decision that it got to. So we have a lot of AI systems that still are black boxes when it comes to understanding the process or the procedures that they take in order to come to a decision. So that's, again, transparency is a challenge for AI systems. And then, of course, lawful basis. So these AI systems, they collect huge amounts of data across the internet to feed into their models. But what is the lawful basis for collecting this amount of data and putting it into the AI system? And again, we've seen that it's important to have huge quantities of data to train the algorithm. But again, what's the lawful basis? So, interestingly, the Information Commissioner Office in England has now launched a consultation series to get feedback on, you know, what is the lawful basis of generative AI for using all the data that they actually use to train their models. So that's interesting, and it'll be interesting to see the outcome of that. How, you know, what do they eventually decide on is the lawful basis for using all this data? So I just want to, there's 2 more points that I'd like to talk about, and I'm not sure if I have much time, but the case of the European Court of Justice that was decided last December, and I'm sure you've heard of this case, but it's interesting for fintech companies and financial institutions. And again, like I said, I'm working with Babeș Bolyai University in Cluj-Napoca. I'm working with financial experts there, and we've come across this challenge where I would be the data protection expert, and they would be, you know, writing AI algorithms, and of course I would try and get them to kind of ensure that there's human oversight. And this has been going on for many years, so this is kind of a bugbear of mine. But now it's been clarified by the European Court of Justice last December that when you create, in the financial sector, when you create a score or a credit score on an individual, it's now been clarified that that is actually an automated decision. And so that automated decision needs human oversight. So Schufa is a credit scoring company, and they created a credit score for an individual. And based on that credit score, the individual was refused a loan. And so the individual then questioned that decision and asked for transparency and asked for an explanation on, you know, how come she got the credit score. She also asked them to delete certain incorrect facts that she believed was included in the data that, you know, finally made up the credit score. But Schufa argued that it was intellectual property, and they didn't want to give too much details about how they came to the conclusion that the credit score that they provided for the bank, who then ultimately decided, based on that credit score, she was not entitled to a loan. So she took it went all the way to the European Court, and in the end, the Advocate General, who was presiding over the case, agreed that Schufa, when they come up with this credit score, is actually carrying out an automated decision. And so therefore, that has implications for fintech and the financial industry in general, because now they will be obliged to provide an explanation to people that have been refused loans, and to provide more transparency on how those credit scores are created. That's going to be challenging because, again, there's a lot of algorithms out there that are black boxes, And so even, the credit score companies don't understand how these AI systems have actually gotten to the decision that they've gotten to. So I'm going to be very interested in looking at that for the next few months and see how that transpires or how that evolves with the AI Act. So my last slide, and I'm not sure if I have much time, but I just want to say, us as DPOs or us as data privacy experts, it's still not clear across the 27 states whether our supervisory authority is going to take on the governance of AI systems, or whether there's going to be another supervisory authority set up, and every individual member state will probably, create their own approach to how AI is going to be governed. But one thing is for sure, that DPOs will have to prepare in some way, because they will have to be at the table when it comes to AI governance. So if you're working in an organization and there is AI in your organization, then, these are the things to consider. So you will have to be, it'll probably be a cross-functional activity, and it's unclear whether the DPO will be leading that function, will be the leading function of that drive for AI compliance. But definitely, you will have to be part of it. Data impact assessments. We have lots of experience. We have 6 years now of experience in data impact assessments. These will definitely be part of the AI compliance landscape. So again, we'll probably be called on to use our expertise in carrying out assessments for AI systems. And as well, we have a lot of experience in putting data protection frameworks in place across organizations, reaching out to various different departments, because data protection is cross-functional and AI is cross-functional as well. So what I would say to DPOs is leverage your experience, whatever role that you will be taking on in terms of AI governance, and leverage your experience in risk-based approach of governance. And so that's basically my advice. And I think I'm coming to the end here. So my last slide is questions. So I'm happy to answer any questions that I can.
So Maria, thank you very much. Very interesting presentation.
Very welcome.
The AI Act will regulate those data processings that are implying a high risk or even an acceptable risk.
Yeah.
And now we are talking about what you mentioned about how to actually take advantage of the vulnerabilities of people, which is something really, really unethical, I would say.
I agree.
Also the fact that in workplace you can measure the emotions of your employees, which again, in terms of privacy, I don't know where would be privacy, intimacy, and there would be nothing.
Exactly. Yeah.
Yeah. So considering all these aspects that you mentioned, I would rather ask you a question, because we still I did not receive anything from the technical team about risk scenarios. You mentioned that impact assessment or risk assessment exercises should be done, even gap assessments to see exactly the overlap also with the GDPR. So what would be, in your opinion, the top risk most often identified when we talk about data protection and intelligence artificial technology?
I think the top risk would be in terms of special category data. So you're talking about the healthcare sector, and if they use AI systems, then they will have to train their algorithms. And in order to make sure that the algorithms are precise and of high quality, they will have to train their algorithms with special category data. So I think that would be very high risk. And I think already before the AI Act comes in, it's a very heavily regulated sector anyway. But so I think that's going to be the most interesting area to look at. How does the AI Act work with all the existing regulations that are in the healthcare sector. And again, another sector would be the financial sector. So that's interesting. And I would identify those two areas as being the most high risk, I think. Again, it remains to be seen how each member state will tackle that governance question. So with all the existing regulation and now the AI Act coming on top of it, it'll be interesting to see how that plays out.
Yeah, interesting. Thank you very much. And I will have another question, considering the development of all these technologies, biometric technology, artificial intelligence, IoT, and clearly its deployment, its usage. What kind of challenges do you think will have a DPO currently and in the very near future, I would say, to ensure GDPR compliance?
Well, I think there's a number of challenges now for the DPO coming up. One of the major challenges I see is if the DPO, of course, the DPO has to be at the table when we're talking about AI governance, but I think the technical challenges of understanding AI systems could be a challenge for DPOs because it's a different requirement, really. It's a different job specification, if you ask me. And so I think we as DPOs will have to collaborate a lot with our colleagues across the organizations because we will have to try and understand how these systems work. Not in too much detail, but we have to understand, the procedure that it goes through in order to come to the decision that it makes. And so I see that as the biggest challenge for DPO. Yeah. But again, I think the most important thing here is communication and making sure that, everybody that needs to be at the table is actually at the table so that everybody can get a good understanding of everybody else's expertise. And so the best decisions can be made based on that.
Yeah. So clearly the DPO should enhance a little bit, let's say, the knowledge that he or she has. Clearly, it is a challenge also with the time to spend on the training and on the professional certifications. Clearly, we need more than 32 hours, as the study from the European Data Protection Board underlined, but still there were, if you remember, there were only few, so the percentage was really low for the DPOs that actually spend more than 32 hours per year in order to keep him or her updated with the legislation, with the jurisprudence, with the practice, with the best practices, and so on. So indeed, it will be a huge challenge here. Thank you, Maria. Very interesting.
Very welcome.
Thank you very much. Now it is the time to invite Massimiliano Papalardo to give us his view on GDPR and, of course, its implementation in the last 5 years. Maximilian, the floor is yours.
Thank you very much.
Sorry.
Thank you very much, Maria, and thank you very much for the invitation in this very interesting conference and for the great presentations. Yes, what happened in Italy in the past 6 years? We can say that the past 6 years have not been boring for privacy professionals in our country. A lot of things happened, a lot of work has been done, and a lot of work is waiting for us in the years to come. Obviously, as well explained by Maria in the previous presentation, AI is a great challenge. It is a great challenge for all privacy professionals and DPOs too. What is the agenda of my presentation? We will look briefly in the developments in the Italian legislation on data protection after the entry into force of the GDPR. We will have an overview of the activities of the Garante, a summary of the activities of the Garante after the entry into force of the General Data Protection Regulation. Then focus on the role of the DPO in Italy and what have been the problems. And finally, we will take a look on what could be the challenges for the next years. Spoiler one is artificial intelligence. In terms of developments in the Italian law, the main piece of legislation is for sure the decree that reviewed the Italian Data Protection Code. Italian Data Protection Code that was based on the Privacy Directive. After the entry into force the GDPR, obviously this piece of legislation has been reviewed. A number of provisions have been repealed. Others have been changed, for example, with regard to the processing of special categories of data, including health-related data, with regard to the processing of judicial data. Another important section that has been reviewed is the one related to criminal offenses in relation to breach of data protection laws. Apart from this piece of legislation with a general effect, there have been a number of other pieces of law with an impact on data protection. I mentioned a couple of them. One of them is the decree that reviewed the functioning of the Do Not Call registry. Indeed, a very serious problem in Italy is related to unsolicited phone calls for commercial purposes. And therefore, also before the entry into force of the regulation, a Do Not Call registry was implemented in Italy. A registry where the subscribers have the possibility to enter their telephone numbers if they don't want to be called for commercial purposes. After the entry into force of the GDPR, this registry has been extended, the scope of this registry. Indeed, originally, it was limited just for the owners of a landline telephone number. Now, the registry has been extended to mobile phones too. So the companies that want to run a telemarketing campaign in Italy had to previously look at this registry and see if that the list of numbers that they want to call are included or not in this registry. Another very interesting piece of legislation with an impact on data protection is the decree implementing in Italy the whistleblowing directive. We know that according to the whistleblowing directive, public and private organizations have to implement whistleblowing channels, allowing the employees to report conducts, to report behavior that are in breach with the European laws. The decree implementing in Italy this piece of legislation include a specific section regulating the obligation under data protection perspective, and therefore the transparency obligation regarding the processing of the data of the whistleblowers, but also about the processing of the data of the reported person. It is provided an obligation for the organization to carry out a data protection impact assessment before implementing this channel. And another set of provisions regard the effectiveness of the exercise of data subjects' rights. in case of a whistleblowing report. So these are few laws with a very important impact under a data protection perspective. But obviously, in order to understand what happened in Italy in the past year, the main source is the Garante. And these ones are some of the key areas of focus. The first one is data-driven economy in its different declination, including profiling, including online behavioral advertising, including loyalty programs, but also for example, the collection of personal data in order to provide customized service for the user. This field is one of the fields where the Garante was particularly active in the past year. But also, as mentioned, another big problem is related to dark marketing, not solely telemarketing, but also spamming. And so a number of proceedings have been opened by the Garante in this specific field. Another very important topic, not only from an Italian perspective, but also a European perspective, is the cookie paywall saga. We know that a number of European supervisory authorities opened files with regard to the cookie paywall issue. And also the Garante opened a number of files. Unfortunately, in Italy, the Garante has not already issued any specific decision in this respect. And so we are not aware on what is the position of the Garante on this very important subject. Another important issue is the data processing by online platforms, and in particular by very large online platforms. And one of the most important profile is the protection of minors, is the protection of underage users. And so it is very important, the implementation of age verification system. And as we will see later, there have been specific decisions in this respect by the Garante. Other important topics, for example, we can't forget that the past years have been marked by the COVID-19 emergency, by the COVID-19 pandemic. And in this period, the Garante issued various opinions with regard to decrees issued by the government in order to regulate the pandemic, and also issued a set of guidelines in order to regulate the processing of health-related data on the workplace. Other important topic, obviously, generative artificial intelligence, and later we will mention a specific decision regarding OpenAI, but also whistleblowing has been another important area of activity for the Garante. With regard to the figures, we can see that the files opened by the Garante as a consequence of reports of complaints filed by data subjects in the first year after the entry into force of the GDPR was around 6,000 cases. After 2019, the number is quite stable, around 10,000 files open and processed by the authority. Another very important innovation introduced by the GDPR is obviously data breach notification. In this respect, we can see that considering both public entities and private entities, the number of notifications filed is in the range between 1,000 and and 2,000, depending on the different years. On top of the guidelines issued by the European Data Protection Board regarding data breach notification, the Garante made available on its website a set of questions and answers in order to provide some guidance on the cases that need to be notified and the cases that not need a notification. As mentioned before, another very important element to understand if an authority has teeth or hasn't teeth is represented by the fines. Italy is particularly active, and we can see from this slide that the number of fines issued in the past years is around 330, at the second place in Europe after the Data Protection Authority in Spain. And also with regard to the entity of fines, the overall amount of the fines issued by the Italian Data Protection Authority is around 150 million, and so it is at the fourth place after Ireland and Luxembourg, that we know have issued very, very huge fine against big tech company. And so excluding these countries, Italy is one of the more active in this. Also in terms of entity of the fines issued. With regard to the sectors where such fines have been issued, we can see that the main field is the telecom market, with three of the most important Italian players, TIM, Wind, and Vodafone, that have been sanctioned with fines higher than 10 millions of euros. And other two proceedings that was concluded with a very high fine. One was related to Clearview AI that was mentioned before by Maria, with a sanction of 20 million of euros. And another one is related to a company operating in the energy field that was responsible for breaching a number of data protection rules in carrying out teleselling campaign. These ones are the highest fines issued by the Garante in the past years. The Garante was active also in reviewing the decisions and the general authorization issued under the Privacy Directive in order to align them with the new provisions of the GDPR, and also issued a new set of guidelines and approved new codes of conduct. Among the set of guidelines, two of them are particularly interesting. One is the one related to cookies and tracking technologies, that is very important for any online operator. But another one interesting is represented by the clarification issued with regard to the processing of health-related data in the healthcare sector, specifying also specific rules for health-related data processed by means of mobile apps. Among the code of conduct approved by the Garante, we can mention the one related to telemarketing and teleselling activities that, as mentioned before, is an area where the Garante is very focused. And another one very interesting is the one related to credit scoring activity. If you take a look to some of the landmark decisions of the Garante, one of them was addressed against Foodinho, that is a global group company, a company active in the Italian food delivery market. And this sanction is very interesting because the authority assessed the algorithm used by the company in order to evaluate the performance of the riders. An algorithm that was also used in order to assign delivery requests. And so in that case, the Garante found that the algorithm was not transparent, that the data subjects, the riders, were not provided with comprehensive information about the functioning of this algorithm, and such circumstance could involve possible risks of discrimination. And so the Garante fines Foodinho for this activity. As well, another important case was the one that regarding TikTok, and in particular the processing of users, of underage users, of minors, since the company did not implement an adequate age verification system, and so was not compliant with the specific provisions of the GDPR and of the Italian data protection law in order to protect minors. Again, as mentioned, very important, the decision of Clearview AI that we have already seen. And last but not least, in March 2023, the Garante imposed a temporary limitation of the processing of Italian users by OpenAI, the US company that manages the AI platform ChatGPT. Different have been the points raised by the Garante. One of them is, again, the fact that the company did not implement an appropriate age verification system. The second one was the fact that the data of users and data subject, personal data, were processed without being properly informed about such processing. Another breach was related to the identification of a legal basis that was not considered proper by the authority. And finally, also the outputs of the platform were not accurate. And for this reason, the use of the platform by the Italian users was suspended for a couple of months. Before concluding this presentation, a couple of slides are dedicated to the role of the DPO in Italy. The report of the Italian Supervisory Authority recently issued in the context of the survey carried out by the CEDPO outline that there are a number of problems. For example, in the public sector, there is a problem of conflict of interest of the persons appointed as data protection officers, since they often holds top management positions within their organization. In the private sector, on the other hand, the main problem is that in case of group of undertakings, usually only one data protection officer is appointed for multiple subsidiaries, and such circumstance may have an impact on the ability of the data protection officer to carry out properly all his tasks. Another issue is, for example, in the public sector, the lack of specialized expertise in data protection of the subjects appointed as data protection officers, a problem that does not exist in the private sector, where usually the subjects appointed as DPO have a good experience and expertise in the data protection field. Another point raised by the Garante is the lack of a clear definition and written description of the DPO's duties. And another one, especially in the private sector, is the fact that not sufficient resources and time are allocated in order to carry out the tasks assigned to the DPO. And finally, another point that is common for public sector DPOs and private sector DPOs is the reporting line. Usually, the DPOs do not report directly to the highest level of the organization where they act. These are some of the problems that we have in Italy, but in any case, as for all the other European member states, the DPO represent an important cultural change and a different approach to data protection. Finally, before handing, these are, in my opinion, four of the most important challenges for the years to come. One is related to the reuse of health-related data for scientific purposes, because currently in Italy it is very complicated, because in order to process health-related data without the consents of the data subject, it is needed a prior checking procedure before the Garante that makes extremely complex the run of scientific research projects that we know are very, very, very important, especially in the implementation of artificial intelligence system also in this particular field. Another one related to the cookie paywall saga is the issue related to the monetization of personal data, the validity of pay or okay model. Another one is the issue related to the deceptive design patterns, and therefore those dark patterns that induce users to provide their consent for the processing of their personal data, because in order to object or in order to make more granular choices, too much time is needed, and so the user do prefer to accept that the data can be processed, for example, in relation to cookies. And finally, as discussed before, artificial intelligence is one of the main challenges for the year to come. So thank you very much for your attention, and obviously I'm available for any questions.
Thank you, Maximilian. Thank you very much. So indeed an interesting presentation as well. So an overview of the activity in Italy. What actually took a little bit my attention, let's say more, it was about this decree that you implemented in March for the transposition of the whistleblowing directive. And here I would like to ask you, what would be the role of the DPO in ensuring the confidentiality of the data of the whistleblower, when maybe even of the other employees that will give explanation statements in an internal investigation following a whistleblowing hint? What's your opinion about this?
Yes, I mentioned in the decree that was issued, there are specific data protection obligations that any organization has to implement. Therefore, if that organization in the private or public sector has appointed a DPO, the DPO has to be at the table at the moment when the channels in order to receive reports from the whistleblowers is implemented. The DPOs have to explain their position with regard also the technical means used for the processing of the reports in order to grant the confidentiality of these reports, and at the same time in order to protect the personal data of the whistleblower. So the role is very, very important, and the DPO has to be involved from the very early stage in order to help the company to implement such channels in compliance with the data protection law.
Thank you very much for your answer. And another question for you would be, what would you recommend a DPO or a data protection enthusiast to do in the next 12 months? Let's not say years, because that would be too utopian. What should his priorities be? And this is my last question for you. Then I will pass on to Daniela, because I need to enter into the other link for the presentation that I need to deliver to the other conference, but I will be back soon to you.
Thank you, Maria. And as mentioned before by Maria, I think that DPOs have to study how artificial intelligence work, what are the specific issues that artificial intelligence involve, what are the most important provisions of the Artificial Intelligence Act and the areas of intersection between GDPR and Artificial Intelligence Act. It is a challenge for all DPOs, but it is very exciting and interesting, I guess.
Thank you very much, Massimiliano. Paul, how is the situation in France? The mic, please. The microphone. Okay.
I will take. Do you hear me? Yes. Can you hear me?
Yes, we do.
Okay, thank you very much. Well, the presentation I prepared was designed to have a large survey of the GDPR impact in the GDPR question, not especially on the situation in France. Forgive me, I missed this point of your event. I prepare 3 points mainly. First, what did the GDPR did in France and in Europe on its main items, which is to protect the privacy and personal data of individuals in the digital environment. Then I will look at the influence of GDPR, which did a lot of new regulation. And I will finish by the fact that GDPR implementation leads to develop many regulations about data, and that we can say that now we are going to have, as we said in French, un droit de la data, a law for data. And first, I will be back to the development and achievements of data protection with the GDPR. The first point, it's an increasing awareness. In Europe now, about 69% of citizens have heard of GDPR, and 71% of US citizens knows about the national data protection authorities, which wasn't the case in every country and everywhere. Even in France, we start about 25 years ago with the CNIL and the law informatique et liberté. And we can see that the awareness about data privacy and data protection issues is stronger now than it was before. The second point is the GDPR harmonized the data protection rules and standards across the EU. In France, we can see that we have the fines decided by the CNIL are more important now than they were before, and we start to deal with the European process to coordinate, to organize a an uniform application interpretation of the GDPR, which wasn't clear the case before. And then the enforcement. This is a main point that GDPR empowers the national data protection authorities to impose effective remedies and sanctions in case of breaches, such as warning, order, fines, and bans. According to us, and as we can see, the fines are more important, we can say, about TikTok and Meta. And last point, the GDPR in France, other legislation and initiative, both within and outside of the EU, to try to protect the privacy and personal data of individuals. The EU, but e-Privacy, Data Governance Act, Digital Service Act, which on many points complement the GDPR. And the GDPR had inspired other countries and regions, Brazil, Japan, and California, to adopt their own data protection law. So, for the point of view of France, the GDPR is a successful and impactful legislation that has improved protection landscape, data protection landscape in the EU and beyond. And I think it's an important point. In fact, GDPR was not only a legal question. We can see that GDPR helps to have more digitalized processes. First, with data portability. The GDPR grants individuals to write they receive their personal data from one data controller and transmit to another one without any problem. They enable individuals to switch between different service providers and benefits from more choices and competition in the digital market. In interoperability, GDPR encourages the use of common standards and formats for data exchange, such as the European data format. This facilitates the interoperability and integration of different systems and platforms and promote the development of a single digital market in the UE. Security, the GDPR requires data controller and processor to implement appropriate technical and organizational measures to ensure the security and confidentiality of personal data. and to notify data breach to the authorities and to the affected individuals. This enhances the trust and reliability of digital services and reduce the risk of cyber attacks and identity theft. Innovation. GDPR supports innovation and development of new technologies and solutions, such as artificial intelligence, blockchain, cloud computing, and because it provides a clear and flexible legal framework. In conclusion, sorry, the GDPR has not only contribute to the data protection in the UE, but also influences the digitalization of processes by enabling data portability, interoperability, security, and innovation. And this GDPR contributed to the creation of a more competitive, efficient, and sustainable digital economy in the EU. In fact, there is also emerging issue from the GDPR, but also from the other regulation. The first point is a fair access, reuse, and sharing of data. The Data Act intend to foster data sharing among businesses, public sector, and individuals, while ensuring fair and transparent conditions for data access and reuse. This could create new opportunities for innovation, collaboration, and value creation, as well as enhance data sovereignty and digital rights. However, some challenges include ensuring data quality, interoperability, security, and compliance with data protection rules. Protection of consumer and fundamental rights. The DSA, Digital Service Act, aims to protect the right and safety of online users by imposing new obligations and liabilities on digital services providers, especially large platforms that act as gatekeeper. This could enhance consumer trust, choice, and empowerment, as well as a safeguard freedom of expression, privacy, and democracy online. However, some challenges include balancing the interests and responsibilities of different stakeholders, ensuring effective enforcement and cooperation across member states, and addressing the risk of online harms such as illegal content, disinformation, and manipulation. Competition and governance for the digital market. The Digital Market Act seeks to ensure fair and open competition in the digital sector by imposing ex-ante rules and sanctions on platforms that have significant market power and engage in anti-competitive and competitive practice. This could foster a level playing field, promote innovation and growth, and prevent market failure and distortion. In fact, we can speak about that and Artificial Intelligence Act, and Maria did it in a very precise and important way. So what we can say now, 6 years after the appearance of the GDPR, well, from its main purpose, it's a success. We are more the world about data protection than we were before. The penalties about bad conduct with data, personal data, are more punished by important fines, as Meta, with $1.2 billion, euro. And but the main point is that we are working in a world which is strongly datafied. This means that we have to deal with a very important amount of data. And this is going to change the way we use data. And we have to take into account also the other regulation which deal with data. So in fact, I'm not a good speaker, but I'm quite a better debater, and it's the way I used to organize my speak to let a lot of time to ask questions. But I saw that in your association, people don't use to speak and to ask questions.
Thank you, Paul. I do have a question for you.
Oh, thank you very much.
You already made a frame. It's a success, the GDPR in France. But considering also the challenges of the DPO that Massimiliano addressed in Italy, and I pretty much feel the same about Romania, how involved is the DPO in everything that happens in an organization?
Well, we have a barometer. So we used to ask every quarter a question to the DPO. The first one is: are you comfortable with implementation of GDPR in your company or not? And one specific question different from quarter to another one. For the last one, the specific question was about artificial intelligence, and about 93% of DPO thinks that they have they are concerned by this question. And a few weeks ago, CNIL, which is a French data protection authority, organized a colloque with the French concurrences authority about the way data are used for competitive use. And in fact, these things are quite linked. And I think that for the DPO, it's quite a natural question to take care of artificial intelligence, because it's data processing with the specific technologies, but the point linked into the use of personal data is the same with IA or more classical algorithms. Is that an answer to your question?
Yes, thank you very much. Thank you. Now I have to speak a little about the situation in Romania, and I have to thank Maria Maxim for already talking about the general frame of the GDPR in Romania. So I can address some of the challenges of the GDPR implementation, especially for the DPOs, but also for the controllers. So first of all, the role of the DPO, it is a challenge. The fact that the data protection officer in Romanian was translated in responsible with the data protection, which leads to a mistaken idea of the controllers that the person in charge must also prepare all the documentation, and in general, if they have the GDPR file, they are compliant, and often ignoring the implementation of technical and organizational measures. And also, this unfortunate translation implies that the DPO is responsible for the compliance. Today, almost 6 years after the application of the regulation, the situation has partially improved for the DPOs or the privacy consultants, because we now have more sources of information to justify the recommended measures that we make to the higher level of management of the data controllers. But on the other hand, most of the sanctions applied by the National Supervisory Authority are still applied for the lack of implementation of technical and organizational measures. Regarding the DPO, the internal legislation, the Law 190 from 2018, added a new case of obligation for the controllers to appoint DPO when the controller processes a national identification number in his legitimate interest. So in Romania, we have 4 cases in which the controller must nominate a DPO. The 3 cases from the GDPR and also one from the internal legislation. However, in Romania, especially in the public system, we still see cases when the DPOs are formally appointed. So the DPO is not really involved and or have the leverage and training lever for a serious implementation of personal data protection. And the fact that this institution of the data protection officer has been translated into Romanian as responsible with the data protection does not help much either. Because as I said, the controllers have the impression that once they appoint a DPO, they outsource the risk and the responsibilities. The second question I have to address is the employment training. The obligation of the personal data controllers to train the staff and also to check the level of knowledge assimilated by the employees following the trainings were confirmed also by the decisions of the courts in Romania. For example, the Cluj court specifies that in order to prove its diligent conduct in terms of staff training in the field of personal data protection, the controllers submitted a series of internal regulation as well as proof of the organization of courses on the topic, but it is very important to emphasize that it is not proof the effective participation of the staff in these courses, nor the effective application of any way of verifying the knowledge and the information level achieved. So it is important to do the trainings, but also to demonstrate the verification of the level of understanding of the informations of the staff. Another challenge for the controllers is the correct legal basis of data processing. Although at a first glance it would seem that this subject of the correct choice of the legal basis for the processing is outdated and long clarified, the consent is still chosen instead of other legal bases. I know the problem should have been clarified a long time ago, but we still find consent forms in relation to employees or used by the public institutions or even mandatory consent forms. And surprisingly, we also found legitimate interest legal bases used by the public institutions. Another challenge for mostly for the private sector is the imbalance of public and private treatment. Because in Romania, the public authorities' fines can go up to approximately 40,000 euros for the public institutions. And also they benefit from a remedial period that allows them to implement the corrective measures ordered by the authorities. Meanwhile, as we know, the private sector has fines up to 20 million euros or 4% of the total worldwide annual turnover. So it is almost impossible for a public authority to be fined, which is also demonstrated by the very small number of sanctions for public authorities in Romania. In 2023, 98% of the sanctions were applied to the private sector, which leaves us with 2% for the public sector. And finally, a new challenge for the privacy in Romania is the pre-university education law. In September 2023, entered in force a new law of the pre-university education, and more precisely, Article 66 of this law was and still is, and I'm pretty sure it will be for a long period, a real challenge for the data protection professionals, and especially for those who are also parents. Although we understand the reasons behind this article, the increased criminality in schools, This Article 66 contains many errors regarding the compliance with the data protection legislation. First of all, it is in fact mentioned in the law prior consultation procedures for teachers, parents, and adult students before the school decides to install an audio-video surveillance systems. Unfortunately, the article introduces the consent of the persons, of the parents mostly, in the educational contract. The agreement, or by case, as the case may be, the written disagreement of the parents or legal representatives for the audio-video surveillance of primary beneficiary will be included in the educational contract. But as we all know, if the data subject consent is given in the context of a written statement, that the request for consent must be presented in a form that clearly differentiates it from other aspects. So, including the consent in the educational contract is not really GDPR compliant. We also draw attention to the condition of informing prior to obtaining a consent, information that was not done at all in practice during this period, September 2023, January 2024. Prior information that should be provided and followed by a separate consent from the educational contract. What follows next in this article of the Romanian pre-university education law does not comply with the minimum legal conditions for consent. Basically, a consent of the majority of parents is introduced. Audio-video surveillance camera will not be installed in the classrooms in which the majority of parents express their disagreement in writing within the educational contract. So the consent of the majority, does nothing to do with the compliance with the GDPR rules, obviously. It particularly draws our attention that the records following a data subject request of access are made available to the parent or the legal guardian or adult student based on a justified request that should be approved by the manager of the school unit. So up to this point, we note that we are dealing with an invalid consent according to the GDPR, majority consent included in an educational contract. We are also dealing with a limitation of the right of access that should be justified and also approved by the school. And it is not specified at any time how the withdrawal of this consent could be made. So between September 2023 until now, such consents have been obtained without the information according to the Article 13 of the GDPR. The question that arises is what happens to an audio-video surveillance systems in case of loss of majority by withdrawal of consent. We still don't have an answer to this question. In the situation of installing an audio-video surveillance system in the classrooms of school units, it is also necessary to carry out a data protection impact assessment, especially because it is a large amount of data of the children and of the employees also. It is specified as a prior procedure the consultation of the teacher, but the legal basis of the processing, it is not yet identified. It cannot be consent. It is also important to note that in the matter of the video surveillance of teachers, we already have a decision of the European Court of Human Rights that there is a violation of the Article 8 of the European Convention on Human Rights in the case of the installation of surveillance camera in the classrooms. So by now it is obvious that this article of the pre-university education law, it is not at all compliant with the GDPR or the European Data Protection Board guidelines or the jurisprudence. Provisions such as the consent of the majority, the justification of requests regarding the right of access, the introduction of the parental consent as part of the educational contract lead to the need to revise this mentioned article. Of course, a case-by-case analysis of school unit, criminal or violent history, and the application of less intrusive privacy measures are required before taking a decision to install such a surveillance system. So now, almost 6 years of the GDPR, I believe that the role of the data protection officer is much more complex than in May 2018. The DPO must also comply with the regulation, be up to date with the decision of the courts, follow all the guidelines, but also study all the sanctions applied by the national surveillance authorities. The privacy and the processing of personal data involves much more than the simple implementation of the GDPR. I'm thinking about AI Act, Data Act, everything that you already talked about before. Therefore, the role of the DPO in the organization is becoming more and more indispensable. Thank you very much. Maria?
Thank you. Thank you very much, Daniela. Very interesting, your assessment on the implementation on GDPR. It is clear that you have significant experience with the implementation of GDPR by the state authorities in Romania. Are they concerned about the level of implementation? Because we have seen that there are authorities that decided not to implement the action plan ordered by Ascpd or handicap being fined clearly for lack of implementation of security measures or even using WhatsApp for state activities. So are they concerned about how they implement it or the level of implementation of GDPR in their institutions that they coordinate and they take care of it? And
Yes.
yeah.
As I said before, this imbalance between public and private sector in Romania, I believe that make the authorities not to be so concerned. The fact that it's almost impossible to find a public authority, I believe that only the ones that are not, they are making intentionally not respecting the measures that the authority applies can be fined. But considering the fact that they have this period for the applying with the measures, I think it's really impossible to apply sanction there. So I believe they are not very concerned. And I'm thinking also about the fact that the DPO being appointed formal, as Massimiliano said before, we also have these issues in Romania, that the DPO doesn't talk directly to the head of the organization. And also we have the problem that they are doing much more besides being a DPO.
Yeah, indeed. And also the fine, the level of the fine doesn't help and do not motivate them.
Exactly.
Okay, thank you very much for your answer, but I have another one. So in 1 minute, what would you like to add as a message for the data protection experts or including the DPOs, so the DPOs, let's say?
I think it's a challenge for us with all the Data Act, AI Act, and everything that follows. We should be prepared, I believe. So the training of the DPO, it is very important. And I'm also thinking about the organizations that appoint a DPO, but that don't also give them the resources. I'm talking about time, and I'm also talking about allowing them to participate in trainings.
Yeah, exactly. This is true. The situation that we can see. Of course, there are also statistics encouraging us. A lot of people started to participate, to be interested on the GDPR, the rights of data subjects, and so on. But still, there is room for improvement, clearly. So thank you very much also for your presentation and your input, final input. So as a conclusion, we may say that GDPR continues to be one of the most visible European regulation for all the stakeholders, maybe not so much for the data controllers outside the private sector. The DPS do not forgive anyone still, as we could see. All the data breaches, including in Romania, are investigated. The fines go up. The technology is developing unprecedentedly. Therefore, the challenges will become bigger for the data controllers, data processors, for the DPOs, including the DPAs, but also for the data subjects. We discussed recommendations for the DPOs or top risk or challenges for them, or how what we recommend them, but not to leave apart the recommendations for the data subjects in the end. So do not offer you personal data without knowing the purpose of the collection. Know your rights and stay vigilant to avoid actually the related risk, as here in the conference explained. Thank you very much to our guests for the participation and to all attendees to this event. I hope you find it useful. So, la revedere tuturor și o zi frumoasă în continuare. Goodbye everybody and have a nice day. So see you. Take care. Goodbye.
Thank you. Bye bye.
Bye.